Hello, distinguished members of Congress. My name is David Cobble. Please excuse my amateur video. This video is in support of this proposed resolution being submitted for the U.S. House of Representatives to pass. The name of the resolution is U.S. House of Representatives Resolution to urge President Trump to take back full authority over the U.S. presidency as mandated by the Constitution. This resolution is necessary because part of the U.S. president's authority has been stolen by the courts. It is also necessary so that President Trump may come to know his full authority as president. At present, he is not aware of his full constitutional authority. Once liberalism is properly stripped away, we see the U.S. president's full jurisdiction. As we shall see, Mr. Trump has constitutional power to remove liberalism from our system of laws because liberal judicial rulings are not law. He has the constitutional authority to stop individual leftist members of Congress from abusing power and to stop systemic lawlessness in states and cities across America. Much of the presidency's power has been stolen through liberalism. From the outset, let's understand that there is no such thing as being liberal with the law. There is only the law, which every justice and judge must obey as written. To liberalize the law means to change it to meet one's whims, which is not law. Through liberalism, our courts operate outside the Constitution, and President Trump has constitutional authority to correct this matter. This is the guy who is responsible for starting the era of stealing the power of the U.S. presidency. He is the late Chief Justice Earl Warren, who ran the Supreme Court from 1953 to 1969. To restore full presidential power, President Trump is urged to demand that the courts return to the system of law practiced by the courts prior to Warren taking over the Supreme Court in 1953. That was when U.S. law was authentically practiced. My credentials for submitting this resolution proposal arises from these two books which I have written on this subject matter. I won't say the titles because I want to avoid the impression that this is a book promotion. My deep research has made me a kind of expert in this area of law. You may know of the legal scholarship of Helen Andrews, who writes of the unconstitutionality of our judiciary. In an interview with National Conservative magazine, she said the legal profession and constitutional law in general had degenerated precipitously since the days of Earl Warren. What she is actually saying is that the courts are not applying real law. We'll hear more from Ms. Andrews as we proceed. Because of Warren, today's judiciary largely does not practice law, but largely hand down political and personal judicial declarations that are passed off as law. That makes them void. This is senior editor John Davidson of the Federalist magazine. Last year, he published an article entitled "The Judicial Insurrection is Worse Than You Think." He calls the insurrection a constitutional crisis, but I submit it is a constitutional crisis only because Trump is tricked into believing he must comply with personal and political judicial rulings, which, as stated, are not law. This is the controlling law on this subject matter. President Trump does not realize the law requires him to disregard and not comply with void judicial rulings. This law comes from American jurisprudence judgments, and it reads, a void judgment is not entitled to the respect accorded a valid adjudication, but may be entirely disregarded or declared inoperative by any tribunal in which effect is sought to be given to it. It is attended by none of the consequences of a valid adjudication. It has no legal or binding force or efficacy for any purpose or at any place. It is not entitled to enforcement. All proceedings founded on the void judgment are themselves regarded as invalid. After the Warren Court took over the Supreme Court, after Earl Warren took over the Supreme Court, he and his cronies finagled the courts and law schools to stop applying this law. They illegally changed the law books to teach that the only way to get rid of a void judgment is to appeal it to a higher court. But it's shown if the judgment is not law, it is supposed to be totally ignored. See the list of pre-1953 case law started on page 3 of the resolution proposal. Now, Federal Judge James C. Holt of the Fifth Circuit Federal Court of Appeals wrote a paper in 2026 that said what judges are after is judicial supremacy. That is also unconstitutional because the Constitution intentionally makes the judicial branch the least powerful branch of government. The Federalist magazine wrote an article about Supreme Court Justice Neil Gorsuch coming down on rogue judges. The headline speaks for itself. Justice Gorsuch gives rogue lower courts the smackdown they deserve. Now, it is clear that the Democrat Party hierarchy is being taken over by communists. And we are overlooking the fact that the readily available way to defeat them is through unwavering enforcement of the Constitution and federal, state, and local laws. This diagram makes my point. This is the way the American system currently works. Politics first, the law second. This is the way the American system is supposed to work. The law first, politics second. If we bring back strict execution of all federal, state, and local laws, leftists will be stopped in their tracks. That's because they must continually break criminal and civil laws at every level to achieve their destructive aims against America. Faithful execution of the law is what corrects society when things go wrong. The law, when consistently applied, corrects bad politics, bad economics, and bad social policy. Our laws were created to protect the American system. Faithful execution of the laws is the way to save America from leftists. The only person having constitutional authority to faithfully execute all laws at every level is the president. Article 2 of the Constitution says the president, I quote, shall take care that the laws are faithfully executed. End of quote. This clause gives the president total authority to move against lawlessness anywhere in the American system, whether it be territories or institutions. The Constitution gives courts and Congress no authority over how the president sees that the laws are faithfully executed. It is totally up to his discretion. As long as the president stays within the Constitution, he is free to take whatever steps are necessary to see that the laws are faithfully enforced. If the courts try to stop him, the law requires the president to ignore the courts. President Trump is being tricked into not applying this law. This is one example of the U.S. presidency's authority being stolen. As noted, courts have stolen much of the president's constitutional authority by introducing what we know as liberalism. That is a leftist concept which means to depart from the law as written. It was foisted upon our system of laws by Earl Warren. Please allow me to reiterate this critical point. There is no such thing as being liberal with the law. There is only the law. To be liberal with the law is to alter the law, which no court has authority to do. When a judge departs from the constitutional law, it is not law. That makes his decision null and void. A court's sole duty and authority are to follow the Constitution and law as is written. That includes the Supreme Court. When a judge moves to liberalize the law, he moves outside the law as it is written. He moves to create his own law, which he absolutely has no authority to do. When a judge acts outside or makes up his own law, his judgment is void. It is void because it is not law. For decades, liberal judges have been making up their own law. And since women are overtaking the courts at becoming judges, judicial decisions are overwhelmingly based on politics and feelings, not law. It is axiomatic that a judge or justice has no authority to make decisions based on feelings. It is axiomatic that a judge or justice has no authority to make decisions based on politics. Being liberal with the law allows judges to base decisions on politics and personal feelings. This is how they have intruded into the power of the presidency and sovereignty of the state. Today we understand that liberal judges are actually undercover communists. They are intent on helping the Democrat Party hierarchy turn America into a lawless nation. They are not mere activist judges. The proper name for them is anti-constitution judges because they enter the judiciary specifically to subvert the Constitution and law. As I have said, Article 2 of the Constitution directs the president to take care that the laws are faithfully executed. That requires Mr. Trump to demand that the courts return to obedience to the Constitution and federal law. That means returning to pre-1953 jurisprudence, which is prior to the Warren Court. As noted, it was Earl Warren who foisted liberalism upon our system of laws. He cleared the way for anti-constitution judges to enter our court system. This video does not allow me time to detail how Warren did what he did. But the paper I wrote on this history can be accessed at this website, the-papers.org. The name, it is entitled, Trump Must End Earl Warren's Era of Disobedience to the Constitution to Shut Down Corrupt Judges. This paper identifies and analyzes the unlawful tricks Warren used to take the Supreme Court outside the Constitution and federal law. Wikipedia writes this of Earl Warren. The Warren Court presided over a major shift in American constitutional jurisprudence, which has been recognized by many as a constitutional revolution in the liberal direction, with Warren writing the majority opinions in landmark cases. It bears repeating that the Supreme Court has no authority or jurisdiction to liberalize our Constitution, and whatever it does outside the Constitution or federal law is not law and is thus null and void. I will only summarize 3 of the major constitutional violations that Warren committed. First, he positioned federal courts to illegally overturn state laws at will, which violates the 10th Amendment and Section 34 of the Judiciary Act of 1789. Section 34 mandates that federal courts must follow state law when states are parties to federal lawsuits. The purpose of the Judiciary Act, Section 34, is to preserve the autonomy of the states. The 10th Amendment was added to the Constitution in 1791, 2 years later, to reinforce Section 34. The U.S. Supreme Court and all federal courts must comply with federal law. They are not above the law. Yet the Warren Court consistently overturned state laws having no authority to do so. On writing my paper, I was able to find 11 cases in which the Warren Court illegally overturned state law and or policies. It was this activity by the High Court that led to the infamous, patently illegal Roe v. Wade decision in 1973. Warren's second major constitutional violation came when in 1958 in Cooper v. Aaron, in which the Supreme Court claimed it is the supreme interpreter of the Constitution. In other words, whatever it says about the Constitution stands. The Constitution gives the court no such power. In Cooper, Justice Warren wrote, "This decision declared the basic principle that the federal judiciary is supreme in the exposition of the law of the Constitution. This decision meant that whatever the courts say about the Constitution is the law of the land, and that it could overturn Congress, states, and the president at will, regardless of what the law or Constitution says. It meant the court is free to misread the Constitution and impose such misreadings as law. The Constitution gives SCOTUS no such authority. This unlawful judicial activity has pervaded and plagued the Trump administration. Justice Warren wrote the Cooper decision, and it is how he paved the way for anti-Constitution judges to enter the judiciary. They base decisions on politics and personal whims. They depart from the facts, law, and Constitution at will. It was Earl Warren who politicized America's system of laws. Warren's third major constitutional violation involved having law schools to stop teaching jurisdiction law. In this context, jurisdiction law simply means a court's order is null and void if the court lacks authority or jurisdiction over a case of subject matter. Prior to warning, the courts correctly deemed that such decisions are not law, thus do not have to be complied with. Such decisions are to be disregarded and ignored. Prior to the Warren Court, the Supreme Court had established a large body of law or jurisprudence mandating that such court rulings are not to be complied with. I have already read the law in this area. In page 3 of the resolution proposal lists 12 other judicial rulings that outlaw compliance with void judgments. Most of these rulings were lodged by the courts prior to Earl Warren. So what happened? Why aren't courts and lawyers today applying this body of jurisprudence to court cases? The answer is that Justice Warren, the American Law Institute, ACLU, and leftist politicians turned law schools into leftist institutions. They began teaching law students to revere judges, and that since judges have the last word on everything, their decisions can never be questioned unless by appeal. They got law books to illegally teach that void judgments must be appealed to higher courts. A requirement that the void judgment be appealed to a higher court implies that the higher court has authority to uphold the void judgment, which it does not. An appeal requirement also falsely implies that the void judgment is legitimate until a higher court strikes it down. A void judgment is never valid or legitimate, and therefore the only proper remedy is to ignore it from the beginning. Moreover, an appeal requirement keeps the invalid court order in force as though it is law, though it is not law at all. In other words, they stopped teaching jurisdiction law after Earl Warren took over the Supreme Court. Pam Bondi is illegally having the Trump administration appeal void judgments to higher courts. Presumably, she was mistrained and miseducated by the leftist law schools. It could never be legal to obey or comply with a void court order, whether or not it is appealed. It is why no court has authority to require void judicial orders to be appealed. It is why the pre-1953 Supreme Court never issued such a requirement. It is why the Supreme Court for over 175 years up to the Warren Court established that the only proper remedy for void judgments is to ignore them and treat them as though they do not exist. Void judicial orders do not exist as law. What this means is that today's courts consistently issue rulings outside their constitutional and or lawful authority and therefore are not law. The vast majority of judicial rulings against the Trump administration lack authority and jurisdiction and thus are not law. Scholar Helen Andrews, in her books and speaking appearances, reflect this state of affairs. In her interview with National Conservative magazine, Ms. Andrews summed up her research with the following statement. The substance of my critique is that constitutional law is basically just made up. All the rules are gone. The left is doing whatever it wants and coming up with constitutional law sounding pretext to label on top of it. There are no rules anymore. Constitutional law is finished. What Ms. Andrews describes is that, when it comes to the courts, the United States is not under the rule of law. We are under, as mentioned, the political and personal whims of unelected judges. It is a matter of public record that the Trump administration has long complained that judges are issuing rulings against his administration in which they lack jurisdiction and authority. The president is not aware that the law requires him to ignore such court orders and that he is authorized to revisit prior void court orders and adjust his presidency accordingly. Now, if I may, I'd like to recap the three major systemic constitutional violations Earl Warren attached to our system of laws. First, he positioned federal courts to illegally overturn state laws at will. Second, Warren claimed the Supreme Court has the final say on what the Constitution of federal law says it means, to give the court authority to overrule Congress and the president at will. Third, Warren and his cronies stopped courts and law schools from applying jurisdiction law, which voids court decisions when judges rule outside their jurisdiction. Jurisdiction law directs that such decisions are to be disregarded and ignored. Now, what are the powers of the U.S. Supreme Court? Its domestic powers are set forth in Article 3 of the Constitution, which states as follows, I quote, "The judicial power shall extend in all cases in law and equity arising under this Constitution and laws of the United States." End of quote. Judicial power then is limited to enforcing what is in the Constitution and federal law. Note that the Constitution gives it no authority to go beyond that limitation. This is substantiated by the fact that one cannot bring a lawsuit in federal court unless he can show the U.S. Constitution or federal law has been violated. That's because that is the extent of federal court jurisdiction. Equity simply means established unwritten principles of law long recognized by the courts. Another word for equity is common law. This is the extent of judicial power. Note that the article does not give courts, including the Supreme Court, power to create new law. It does not give the court power over the U.S. presidency. Courts can only tell the president what to do if he violates a specific provision of the Constitution or federal law. In other words, federal courts exist solely to ensure that people comply with the Constitution and federal law. As for the president, Article 2, Section 3 of the Constitution mandates that the commander-in-chief be a law and order president. That is mandatory. The president, here it is again, the president shall take care that the laws be faithfully executed. Note that the provision does not distinguish between federal, state, or local laws. It refers to every law in the country. The Founding Fathers intended for every jurisdiction and institution in America to be faithfully grounded in law and order. Article 2 gives the president sole authority to address lawlessness in every facet of society. Note that the provision does not authorize the courts or Congress to interfere. Liberalism is lawlessness. And Article 2 authorizes President Trump to demand that the justices and judges put an end to the liberal agenda and apply only the Constitution and federal law as they are written. Article 2 also authorizes him to restore law and order to blue states and cities like he did in Washington, D.C. That's all. That is all, members of Congress. I'm sure President Trump would appreciate passage of the resolution as soon as possible. Thank you.